And then there's an Article 19 right after that. That's on parking, and that's sponsored by a gentleman by the name of John Sullivan. And that should move very quickly. And then Article 20, which is the gross floor area, and 21, which are the height of the buildings, the planning board is going to indefinitely postpone, recommend indefinite postponement on those right away. So it appears to me that we should be able to get through Article 17, 18, 19, 20, 21, and 22 to 26 before the end of the evening for sure. And then we'll make a decision at the end of the evening when the next meeting is. And if we're successful in getting through 26, then the next meeting would not be on Thursday because it's a holiday, and it would not be on Monday because we really don't need to meet. We'd be able to finish the meeting on the 18th. So progress in the next hour will determine when we're going to meet, but I suspect it's going to be the next meeting will be the 18th. So having said that, we turn to Article 17 to see if the town will vote to amend the zoning bylaw 355. And the chair recognizes Mr. Johnson.
Good evening once again, and thank you. I would like to move for indefinite postponement on Article 17. Originally, when Article 17 was drafted, I believe it would redress the requirement of a special permit imposed by new bylaw. However, under further investigation with Town Council and Land Council, it was determined that it could not be done here because that section was removed under recodification. So I would ask for indefinite postponement on 17.
Planning board have any problem with that, sir? The planning board's indicating they agree. All those in favor of indefinite postponement, please say aye. Aye. Opposed? The ayes have it. Motion carries. Article 18, to see if the town will vote to amend the zoning bylaws for the town of Winchester with respect to section 355. And that's on page 31 of your motion booklet, ladies and gentlemen. Chair recognizes again Mr. Johnson.
Yes. Good evening. Hopefully Article 18 will address the recodification and the effects it had on the expansion.
Get a little closer to that mic, Jim.
Hopefully Article 18 will address the recodification, the effects the recodification had on the expansion of a single-family and two-family home in a non-conforming use. There are approximately 1,600 homes affected in Winchester by the change of this bylaw. When the town adopted recodification of the zoning bylaw spring of 2009, I was led to believe there were no substantive changes being introduced. Recently, however, I have learned that the recodification placed limits on the right of approximately 1,600 homeowners of single and two-family homes when they wanted to make additions or improvements to their home. Under town practices prior to recodification, additions, alteration, or structural changes to non-conforming one- and two-family homes were permitted as of by right, as long as the addition did not increase the non-conforming nature of the home. This was bylaw section 3.23, section 3.14, and the last sentence of section 3.45. During the recodification of these sections, Attorney Mark Rakowski pointed out that the one- and two-family additions, alterations, or improvements being addressed under a matter of right under the sections of the law were not consistent with Massachusetts law. The final draft of recodification in this section, on this subject, section 3.55, provided recodification by eliminating the above references to sections and substituting them with three specific case law instances where the additions, alterations would not increase the nonconformity of the nature of the structure and therefore was permitted as a right. However, the recodification also added the provision that additions, alterations could not exceed 25% of the gross floor space of an existing home. What this means, if you have a 2,000 square foot home and you wanted to make an addition, the biggest addition you could make is 25%, or approximately 500 square feet, which is a single room of approximately 10 by 17, or a two-family addition of approximately 12 by 12 on each floor. The addition of the 25% required created potential for alterations or additions to any house that is non-conforming. In addition, the recodification lacks the definition of gross square foot under certain conditions. Because the 25% restriction appears to me to be a policy change that should have been reviewed by town meeting and the public in a public hearing, I have placed Article 18 as a warrant. After discussion between myself and town council and his discussion emails with the land council, Mark Rakowski, attorneys Rakowski's discussion with town staff, I believe this amendment, the current bylaw drafted by attorney Rakowski and the proposed Article 18 eliminates the 25% restriction as the most practical way to go forward. I will remind anybody that if the planning board once this article is passed and wants to revisit it, they are welcome to revisit it next spring. They can revisit it by having public hearings, addressing the issue, particularly getting input from the citizens, and then bringing it to town meeting for debate. Thank you.
Further on the question? We have to get a recommendation from the planning board. Mr. Bottaro.
Thank you, Mr. Moderator, Mr. Johnson, selectmen, members of town meeting. I don't seek out these predicaments. They just seem to find me. Let me just say, this is a difficult presentation to me because I was part of the committee, worked very hard at this, and when we started the recodification process that I was involved in, which is I called Phase 2, the objective was to streamline it so that we understood the law well enough so it could be amended. And the clear objective was to make no substantive changes other than what we had to do to update for case law and statutory law. The goal was to make it transparent, make it be no changes. If we did not meet your expectations, I'm very sorry. That was not what we were trying to do. I'm happy to hear from you tonight, and I'm happy to see Mr. Bobrowski here tonight to answer some of the more technical questions about how we got where we got. With that, let me explain a little bit of the history of where we are with this Article 18, and then prepare for discussion. I think you've had a lot of handouts. We have one there which sort of explains the background to Articles 17 and 18. I'm not going to go through it. I'm just going to cover the key points of the current 3.5.5 very briefly, and then look forward a little bit. The current 3.5.5 regulates alterations and additions to single and two-family non-conforming houses, allowing additions by right if the gross square footage, as Mr. Johnson said, is less than 25%. I would not hold us to Mr. Johnson's math in terms of the room sizes. But in cases where the nonconformity is due to setbacks, insufficient setbacks, insufficient frontage, or insufficient lot size. The second two, insufficient frontage and lot size, my understanding of what Mr. Bobrowski has told me, were not actually covered exceptions under the old law. And one adjustment that we're making, the practice seemed to have evolved that those were being permitted generally. So the practice was to include those. We also were reacting to a recent case that occurred in 2008, which said that non-conforming single and two-family structures needed a special permit process unless there was a carve-out done by the town. The judgment of the committee that was working on this, which included myself, Peter Van Aken, Josh Alper, town planner, the then assistant town engineer, current town engineer, and Mr. Bobrowski, and other people had some input, was that this reflected actual practice, and the idea was to have all those, what I would call non-exceptional additions, be allowed as of right. That was the thought process. I think if you have a different opinion on that, that's fine. That was our judgment at the time. Again, that's the point of the discussion. That's how we got where we were. We're trying to do the main objective, which is to get the law readable and make no changes except what we thought were required by state and by statutory and case law. I think that's what I'm going to say about the current law. Going forward, and I think we've got some choices tonight. The choice is either stick with the 355 for now or the Article 18. And those are the current choices. I do think that going forward, the town, the planning board, with broader stakeholder inclusion, needs to look at all of this, because I don't think any of those are a great way to do it. Some of the thoughts about ways to navigate this with finer grained analysis is maybe there's different percentages appropriate for different neighborhoods, or based upon the context, meaning the other size of the houses on the street. These are approaches that other towns have considered. Maybe look at, as long as there's not too much impervious surface being created, and I can't tell you tonight what too much means. Maybe allow additions up to a certain square footage. Maybe review the underlying zoning, and the town has created this zoning of town meetings past that I think no one here was a member of. They created the zoning, created all the non-conforming structures. Why do we have so many non-conforming structures? I would think a deeper analysis, other than what we had time for, as this came up to the planning board's attention in September, would be very helpful to this provision of the law. And I'd like to take a look at the universe of typical permits for a typical year or so as to what kind of permits are coming up. And the idea would be to make sure that we've got a law that works for our town, that makes sure that the non-exceptional expansions and alterations don't require a special permit process. 2 minutes?
No, you haven't. You could.
Okay.
Got about two to go.
I heard something beeping, and I'm conditioned after all these years. So I would think we want to analyze really what are the permits, and are we, what are we trying to what is the quantity of this kind of permit that's a problem, that kind of a permit. Look at other towns' approaches. We have not done a systematic look at that. What we've seen so far is basically on this percentage, we've seen 0, we've seen 50%. It doesn't mean it's right, but at least look at what other towns have done. Look at our policy objectives regarding setbacks and lot size and frontage. And if, to the best we can, assess the impact of different approaches on the town's bottom line. The point here is that expansion of properties can lead not just to increased revenue from assessments, but can lead to extra expenses on the town. Now, a number of you will have a tough decision to make. If you believe that you were not properly alerted to this being a change, and you think it's a significant change, and you think that we need to go back to something as close as where we were, I respect that. I would argue that the current 355 is actually closer to that, because the proposed 18 with the 3 carve-outs, A, B, and C, for exceptions for frontage nonconformities, lot size nonconformities, and setback nonconformities, actually expands the old law, which only referred to setbacks. The way I read it, if you can find, and you've got the old law in your Article 17 motion, I can't find any reference to frontage or lot size in there. Mr. Bobrowski, again, can clarify if you have questions or details. So we think that that the current 355 actually navigates that problem better than 18, which we think has the risk of expanding the permitted alterations beyond what the original law did. And we just raised a question, there's uncertain fiscal impacts to the town of that expansion. Thank you.
Thank you, Mr. Bottaro. Yes, sir, way up back.
Mr. Pataro, could we have some clarity around Mr. Johnson's reference to the 25%? My reading of this was that you could build greater than 25% provided that you came back and received approval from the town.
Mr. Bottaro?
That's my understanding. I don't see there's Mr. Johnson. I think, I don't know whether you said that, but we're all in agreement on that point.
I just want a clarification that I didn't want to leave it that one could only build 25% and nothing more than that. And I have a follow-up question.
Yes, what I had said that previous to the recodification, by right you could build any size addition as long as it did not exceed the non-conforming use. Now you can build only up to 25% by right. Anything over 25% requires a special permit process, and it's my understanding that the special permit process is a long process and it could delay the possibility of expansion by several months. And it could be as much as $10,000 for the permit process.
A follow-up question, sir.
Yes, Mr. Pataro, could you speak to the potential delays? And then I'm curious as to what protection abutters would have if it were a developer coming in who's looking to flip a home. If we went back to the old ruling, and we're not going to be notified, what protection do abutters have other than filing, at the 11th hour?
I'll answer best I can, subject to correction by a member of the ZBA or by town council. I mean, it's a complicated answer. If you have ability to build as of right, you get a building permit from the building inspector, and then there's a certain period of time, and I don't know the period of time that abutters can appeal that to the ZBA. 30 days. I'm lip reading town council. Thank you. And then that will go to the ZBA. This is the standard process. If it's a special permit process, I don't know all the times and dates, but you go there and there's advance notice to the abutters and an opportunity to participate, and there's a review by the ZBA panel and a more comprehensive judgmental, if you will, kind of analysis. The test, which I know all too well, is that something is not substantially more detrimental to the neighborhood. So that's the essence of it. Now, one of the concerns that we had with this Bjorkland case, which had basically invalidated the prior law, is that there is another section, and I will rely more on special counsel and town counsel on this, that if a building permit has been granted invalidly and someone, your neighbor gets angry within, say, 6 years, which I believe is the statute of limitations, they can challenge the validity of that permit and the construction, and the unfortunate ultimate remedy could include an order to tear down the illegally built structure. Again, I'd like, if you have detailed questions, I'm not a real estate attorney, but this is what I believe I've learned. So, did I answer your question?
Further on the question? Yes, sir.
Hello, I'm John Jubilo from Precinct 8. I think what this article boils down to with me is it's really a balance that we have to strike between limits on what a homeowner has and the burden that a person building has on a neighborhood when they don't do it in a reasonable and responsible way. And so that's really the balance here. It's not about homeowner rights. It's really about the town of Winchester and the character of the neighborhoods. And what I'd like to propose is, I don't think either one of these articles, the proposed amendments or the original article, address the issue the way the previous zoning did. So I think they're both substantive changes, which is really the root of this problem. This was meant to be a non-substantive change, and in fact they were. And so what I'm proposing is that the motion be amended and that the building 3.55, non-conforming single and two-family residential structures, which was the amended motion, that the third line of that motion, the word building commissioner, be changed to ZBA, because 3.45, section A2 of the old code, defined the ZBA to have the responsibilities that paragraph is defining the building commissioners. In other words, that paragraph 3.55 of the amended motion would read, non-conforming single and two-family residential structures may be reconstructed, extended, altered, or structurally changed upon determination by the Zoning Board of Appeals that such proposed reconstruction, extension, alteration, or change does not increase the non-conforming nature of the said structure. The following circumstances shall not be deemed to increase the non-conforming nature of the structure. And this is very important because, remember, the ZBA is really here to protect Winchester, not to protect the developers, but really to protect the residential taxpayers who form 95% of our tax base. Okay, so here are the things which the new amended motion suggests do not increase the non-conforming nature of the structure. Item A, alteration to a structure which complies with all current setback, yard building coverage, and building height requirements. Key change, but is located on a lot with insufficient area. The old zoning code said if the lot was in a minimum of 5,000 square feet with a minimum of 50 feet frontage, that automatically pushed it to the ZBA. Now it's saying, but it's located on a lot with insufficient area. That no longer makes it non-conforming. So if you have a 2,000 square foot house on a 3,000 square foot lot and you want to increase the size of the house to 3,000 square feet, well, that doesn't make it any more non-conforming. That's what this is saying. So I would propose that we change paragraph A to say, alteration to a structure which complies with all current setback, yard, building coverage, and building height requirements and is located on a lot meeting minimum square footage for the existing use and zoning district, where the alteration will also comply with the said requirements. Item B.
Excuse me, before you go much farther, that motion, even that part of it is out of order.
Why is that?
The zoning laws are very specific that the public has to be adequately informed in the warrant, and that does not, they have not been adequately warned about this motion, which is not in writing either. I mean, this is a very complex thing here. And the real purpose, I think, of you're trying to solve the problem that what you do to make it better. And that's not what this is about. This is about whether you approve what's in the document right now or whether you go back to what was before so that we have a different process with public involvement where you can appear at a public hearing and present your ideas.
Sir, I'm not trying to, I'm trying to go back to what we had before the zoning was quote-unquote recodified and in fact was changed substantially.
Well, you can't do that. That's what the Board of Selectmen tried to do in Article 17, and everybody, including myself who reviewed it, thought that that would solve it. But the problem was the zoning recodification struck other sections that 355 was dependent upon. Is that right, Mr. Welch?
That is correct, sir.
Thank-
3.41 sentence lots.
Right.
The key sentence that incorporated what was later with the recodification, but for
Right.
the addition of the 25%.
Right. So, thank you very much.
Well, I just have one thing to say. I recommend that this article be voted upon unfavorably because, in my opinion, neither one of these articles, the current or the motion that's made to modify it, address the issue. Thank
Fine.
you.
Further on the question. Yes, sir. Mr. Swan.
I have a question and then a statement.
Yes, sir.
The question through you is, I would like to be clear that this is Mr. Johnson's motion and not the Board of Selectmen.
We'll ask them to indicate maybe the best way. Do the Board of Selectmen all approve of this article? Mr. Howley? We have not voted yet. The Board of Selectmen has not voted on this? We're listening to this discussion. I guess you got the answer.
Thank you. So I'm Bill Swan from Precinct 7. Looking at all of this, we recodified our zoning bylaw last town meeting to clarify it and get rid of the ambiguity in it. And it seems to me that, the planning board, as Mr. Bertaro talked about in the committee that was doing the recodification, identified a big hole and unclarity in the piece here, which allowed a lot of different things to be done to non-conforming structures that may or may not have been a good idea. And as somebody recently just said, sometimes a developer might be stretching these laws, like we had with the two-family houses a couple of years ago before we changed that. So I would claim that, I think the team that recodified the bylaw looked at this and said, hey, we don't want to make this onerous on the average person. But if someone's doing something big, we'll have a piece there. They looked at the case law and said, hey, we can create a carve-out that goes past it so we don't need the ZBA involved on small things, 25% or less. It sounds reasonable to me. The few people who go above that will have to go to the ZBA, which isn't all that onerous for doing a project that's going to be that size. So I would strongly recommend that we pass this, this piece here, and then as Mr. Bertaro says, come back and really evaluate what properties are affected, how much are they affected, what are the issues that could come of that, and what are some other solutions for carve-outs here that would make sense and make it easier for people in the future to make changes to their house without hurting their neighborhoods. Thank you.
I see a gentleman up in the audience way back, Mr. Murray. Pardon? Mr. Murray, sir.
Mr. Moderator and members of the town meeting, I'm here today on behalf of the Chamber of Commerce. Back in October of last year, the Chamber of Commerce formed a subcommittee on zoning in anticipation of studying zoning articles that might affect the Chamber, more particularly articles that probably will be coming up sometime in the future dealing with the downtown center area. But we did meet in September, and we had a vote of the members of the subcommittee, which consisted of the president of the chamber and the members of the board of directors. The group, consisting of 6 members, unanimously voted to recommend favorable action on Article 18. And this was done after careful consideration of the history of this article, the case law and statutory law, and that matter was then brought to the full board of the Board of Directors of the Chamber of Commerce when they met just this past week, and the board on November 3rd unanimously voted to accept the recommendation of the subcommittee and to recommend to the town meeting that favorable action on Article 18. Now, that completes the report that I've been asked to give to this board from the Chamber of Commerce. The comments I'm about to make are not ones that reflect the views of the Chamber of Commerce. The Chamber of Commerce did not have an opportunity to review the material that was submitted on Friday by the Planning Board, but I thought it might be helpful if I could address that and some of the comments that have been made. I have practiced law here in the town of Winchester for the past 40 years, and during those past 40 years, I've appeared on numerous occasions before the Zoning Board of Appeals, before the Superior Court on zoning matters, and the Land Court on zoning matters. I've had an opportunity to review carefully General Laws Chapter 40A, Section 6, as well as the case law. And there is no question that the change that was submitted as part of the recodification back in April of 2009 does represent a substantial change from the previous zoning bylaw. Chapter 48, Section 6 is intended to give special relief to owners of one- and two-family homes that fell into the category of being pre-existing non-conforming. Every building permit is open to a challenge for a period of 6 years. Section 3.5.5 does not change that. Building permits issued based on a determination that the so-called 25% trigger has not been met are still subject to that same challenge. The Brooklyn case involves only one type of nonconformity, and that nonconformity was a lot that was smaller than the then existing zoning bylaw. The town of Norwell had changed the zoning bylaw to increase the size of the lots. And it involved a situation in which the house that wanted to be, the developer wanted to build, would change from 675 square feet to 3,600 square feet, an increase of almost 5 times. All of the case really stands for is that when the nonconformity is in an undersized lot, that the increase in the size of the structure could, in some circumstances, be deemed to be an increase in the nonconforming nature of the structure, thereby requiring a special permit under 40A.
Mr. Murray, do you wish more time?
If I may, Mr. Moderator, may I have 3 more minutes?
We'll even give you 5. Moved and second that the speaker's time be extended 5 minutes. All those in favor, please say aye. Opposed? The ayes have it.
Thank you, Mr. Moderator. If we adopt Article 18, it would still not allow a permit or a person to create new nonconformities as to lot coverage, height, or setback, which would clearly be more nonconforming than the existing conditions. As to the argument that if we adopt the new provisions, no notice will be sent to abutters, no plans will be available to the public, and no public hearing will be held, and the building commissioner alone will make the final decisions on issues of building permits. This is precisely what we had before recodification of the zoning bylaw passed in April of 2009. It is precisely how the process works with all new buildings in town. If you had a vacant lot and you wanted to build a house in that lot, the building inspector would look at the plans, would look at the zoning bylaw, and would make a determination whether or not the house could be built. And the zoning enforcement officer, zoning administrator, is knowledgeable, obviously, on these issues, and then would either issue the permit or not issue the permit. That's the way it has always been, and that's the way it still is when a person were to build a house on a vacant lot. If notice is so important, why not require a hearing for every new house that is built? Obviously, this would be an unreasonable burden and one that would swamp the ZBA with hearing requests. As to the reduction of property values, one could argue that the 25% rule would diminish values rather than increase them by placing additional burdens on homeowners that they would be unable to use their property to their highest and best use, which is essentially the definition of value. The Planning Board cites Massachusetts and federal law. I can say categorically that there is no Massachusetts or federal law that requires a 25% threshold. All the matter before you would do is eliminate the 25% threshold. What does the 25% threshold mean to a property owner? It means that they need to file an appeal with the Zoning Board of Appeals if the extension is more than 25%. This requires hiring a registered land surveyor in order to prepare a plot plan, certifying the existing condition and showing the proposed condition. It involves hiring an architect to draw up elevations and showing the elevations, the alterations and additions. It involves filing 16 copies of plot plans, 16 copies of elevations, and 16 copies of various forms with the Zoning Board of Appeals, together with a filing fee, paying for the cost of publishing the notice in the newspaper, and appearing before the Zoning Board of Appeals to present their case. Materials must be submitted in a minimum of 40 days prior to the hearing date. Decisions must be filed in writing by the Zoning Board of Appeals within 90 days of the hearing, and after they are filed, there's a 20-day appeal period before a building permit can be issued, which could result in a period of up to 150 days, or approximately 5 months, before construction could commence. In order to bring the bylaw back to where it was before the recodification, the best thing for the town of Winchester to do would be to vote in favor of Article 18. In the future, the planning board can propose changes to the bylaw, and all interested parties will have ample opportunity to be heard. By voting yes on Article 18, policy decisions can then be made by you, the town meeting members, as to whether or not the change is appropriate. Thank you very much for your attention.
Thank you. Gentlemen, you've already spoken. There's Mr. Conti. You can speak again, but I got to hear people that haven't spoken.
Thank you, Mr. Moderator. Mr. Murray has given us an excellent explanation of what we're confronted with. I would point out that the recodification that affected 1,600 homes in this town is not an insubstantial matter. It is a very substantial burden upon the homeowners who are affected by this. And as we just heard, it is a lengthy and expensive process to go before the Zoning Board of Appeals to make any increase in the size of a non-conforming structure by 25%. And I would point out, this only affects single and two-family houses. It's not going to affect any commercial properties. It's only going to affect homeowners, single and two-family homeowners. And you know, let's remember, these non-conforming structures are structures that exist, that are in the ground, that are, and have, in most cases, been there for many decades. The town ought to be encouraging people to make improvements to property rather than to allow property to deteriorate. And you know, anything that makes it more expensive and more difficult for homeowners to improve their property is not a good thing for this town. We ought to be encouraging people to make improvements to property, and I would urge the town meeting to support Article 18.
Thank you. There's a gentleman up in the back there. Mr. Averson, is it? Yeah.
Thank you, Mr. Moderator. Robert Abrahamson. I'm not a town meeting member. I'm in Precinct 4. I thought I'd just share with you how this has personally impacted my family. We purchased a Victorian home built in the late 1800s, hoping to renovate it. The house happens to be too close to the street. We're 15 feet from the street. I guess we're supposed to be 25. We want to put on an addition to the back of the house. We have 4 young kids. We need more space. We want to put on a kitchen, family room, master bedroom, bathroom, make more space for the kids. The addition is not going to change anything about the existing non-conforming nature of the structure. The front of the house, that's the non-conforming part, is going to be the same. The addition is going to be only in the back. It's going to comply with all setback requirements. The yard spaces are fine. The backyard's fine. It's not going to occupy too large a percentage of the lot. It's just, we're now required to go and get a special permit, which is going to take another 3 to 5 months. Hire an architect, hire an attorney, hire a builder. We actually have a construction loan that's scheduled to close in December, and we're going to lose out on that now and be penalized, you know, $5,000, $10,000 because we can't move forward as a matter of right at this point. But that's how I've been personally impacted. I think policy-wise, we do want to encourage homeowners to improve their properties. This town depends on its subsistence depends on the tax base on the property taxes. Every $100,000 increase in property values is another $1,000 for the town. And that's every year. I'm basically offering to pay the town $3,000 to $5,000 more per year, and I'm being discouraged from doing so by people telling me I have to go through the special permit process at this point. I think that's bad policy. Earlier up on the slide, someone showed 40A. I wonder if we can bring that back up.
40A. This
40A,
gentleman.
section 6. The only point I want to make here is that leaving the 25% provision in the bylaw, in my legal opinion, I'm a lawyer, would be inconsistent with this state law, which clearly allows the owner of any existing non-conforming home to put on an addition so long as that addition would not intensify the existing nonconformity or introduce additional nonconformities. This says that the zoning laws don't apply to a homeowner in my circumstance. Putting this 25% rule in is something the town is not allowed to do. The only way the town can allow or require a homeowner in my circumstance to get a special permit is if we're increasing the existing nonconformities or introducing new ones. That's all I had to say. I'd be happy to field questions from anyone if anyone has questions for me.
No, yeah, I'm running the show. No, that'll be fine. Thank you very much. The Board of Selectmen wanted to be recognized, and then I'll catch in that order.
I wanted to report to town meeting. This has been a subject of some discussion at our table over the last several weeks. Been a lot of back and forth. We really felt that in order to make a really informed decision, we needed to hear this discussion just as you have. We voted 4-0 to recommend approval of Article 18, and we do think that the questions of the threshold, while it may be the subject of a fair policy discussion, that discussion now, if in fact the planning board wants to bring it forward, is the type of thing that I think ought to happen between now and the next town meeting. And then we can all participate in that discussion at that time. So the board has voted 4-0 to recommend approval of Article 18.
Thank you. The gentleman up on the aisle, up back in the black shirt, the guy that's, you got to stand up so we can see you. Thank you.
Thank you, Mr. Moderator. My question was actually going to ask the Board of Selectmen to take a vote, since I recall they did that at our special town meeting at McCall on a separate matter. So now I'll simply say to Mr. Halley and your colleagues, thank you for doing so. I appreciate you taking the time to discuss that tonight and to throw your weight into the discussion.
Thank you. The gentleman right here. God bless.
Hi, I'm Jack Richard from Precinct 1. I was, in my prior life, a real estate attorney for many years, so I have a working knowledge of this, but I've been away from it for about 10 years. First thing I want to say is when we voted as a town meeting...
Put the mic up, please. Yeah.
When we voted as a town meeting on the recodification, we were told that it was, in fact, just a recodification. And I really need to say that the sincerity and honesty of Mr. Bottaro, when he was essentially, admitting that was my intention, I believe him 100%. I came here thinking maybe someone tried to pull a fast one. I am absolutely certain that was not the case, and I'm proud to be in a town with people like this who volunteer their time, who disagree with me very much about the balance between individual property rights and the rights of the neighborhood, but are so open about it and so sincere in all the time they put in, and I really appreciate that very much. I want to say that. I would like now to get on to the point that I disagree with his policy position very much, because when the town meeting voted for this change, we were told it was not a change. So my appeal is a difficult one, but it's to basic fairness. Even for those of you who agree with the law the way it is, I think you'd have to agree that it was put in a sincere but incorrect manner. So the only fair thing to do is to roll it back as best we can. I sympathize very much with the homeowner, Mr. Abramson, and what he's gone through. And in my own personal feeling is that in this balance between individual property rights and the rights of the neighborhood, I come down, my strong presumption is with the individual homeowner, And as to the question as to what is the protection to the neighborhood, you have an existing zoning code. You must be in compliance with all of the provisions of the zoning code to make any of these changes to a non-conforming home. This beautiful town you all love was built mostly before there was even a zoning code. So when you pass the code, naturally, a lot of houses are not going to comply, but any changes need to comply. I believe he's also correct when he says that this law is contrary to state law. That is, the state law already exempts single and two-family homes that are not increasing their nonconformity so long as they comply with the rest of the zoning code from further regulation. That is final. And I think if I were a homeowner and I brought a challenge to this law as it's currently written, again, with the best of intentions, I think it would not survive that challenge. So again, I applaud very much the manner in which it came. I disagree as strongly as I could with how it stands, and I'm proud to be in a town with people like Mr. Bottaro on these boards.
Thank you
Thanks.
very much. Further on the question. Gentleman, right there.
This is D. Abjurius, Precinct 8.
Can't hear you, sir.
D. Abjurius, Precinct 8. I'd like to reiterate what the gentleman said about the transparency and dedication of the planning board. I was at several of the hearings where the recodification was discussed, and they were very, I think, quite thorough and quite open about their intent to recodify but not change in substance. I'd also like to note that I was probably one of 3 people from the public who were at those hearings. So while this great recodification was going on, and there was a chance for public input, very few of the public showed up. And I don't think that does say something good about our community. But I would like to move on to my question, which is I've heard from several attorneys who claim that the 25% is not in agreement with the state law, and I would really love to hear from special counsel as to why the 25% was put in so we could hear the counter argument.
Chair recognizes Mr. Attorney Bobrowski.
This is a complicated field of the law, town meeting members, and I'll try to be as succinct as possible, but this is known as the black hole of the Zoning Act.
Can you get closer to the mic, sir?
Sure. This is known as the black hole of the Zoning Act, so don't expect too much. In the Bjorklund case, which was decided by the Supreme Judicial Court back in 2008, essentially the result left many of us scratching our heads, but we pretty much came to the conclusion that virtually everybody had to go to the ZBA in order to have a determination made from the outset whether or not the proposal that would change the non-conforming single or two-family home increase the non-conforming nature of the home. That's the key question here. Does it increase the non-conforming nature? If it does not, earlier case law had suggested that the applicant was entitled to the issuance of a special permit. That's simply wrong as a matter of law. Entitled to a special permit is not. It's an oxymoron. A special permit is discretionary by definition. And in fact, I had written in a piece that I prepared that I think the appeals court intended entitled to the issuance of a building permit. So from that point on, municipalities began doing what are essentially carve-outs. Sudbury had 5. I redid their zoning back in around 1999 or 2000 and recommended 3 of them. Your prior bylaw had 1. If the structure was non-conforming because it was in a side yard and the proposed alteration was in a different yard and it complied fully with your zoning, you could get a building permit. It was as of right. But I pointed out to the committee at that time that was an incomplete view of things and in fact inconsistent with your practice. What if the lot was deficient in area but the proposed addition complied fully? What if the lot was deficient in frontage but the proposed addition complied fully? The practice of the building department indeed was to give those people a building permit, just as if they were in the side yard and the addition complied fully, which was the only carve-out mentioned in the old version of the bylaw. Around the time we were discussing this and adding what essentially are A, B, and C in your handout for this evening, Bjorklund was decided. And Bjorklund was a case in which the house was quintupled in size and it met fully the front, rear, side setbacks and the height requirements. And for the policymakers on the board, that was an omission that the old bylaw did not address. And so through the process of discussion, it was the recommendation of the committee and it was approved by this town meeting after public hearing and the warrant article was presented to you to add the term 25%. Now, remember what I said at the beginning of this. Bjorklund stands for the proposition that all of this goes to the ZBA, but Bjorklund does recognize in footnote 16, many municipalities have placed exceptions in their zoning codes permitting additions and structures of the type listed in the examples of non-intensification. And so the practice that was adopted by many communities was to state A, B, C, and in many communities up to 50%, up to 25%. Those are common features. I'm on my Concord Planning Board. We have 50% in our bylaw as a cap on A, B, and C. It's not necessary that you put a cap of 25 or 50%, but it certainly meets footnote 16 suggestion from the Supreme Judicial Court that you can list what you will allow as of right, and everything else must go to the Board of Appeals for a special permit. And that's exactly what the article in front of you this evening does. It lifts the cap, and it says A, B, and C are as of right. That may not be the right answer because some large proposals will go through without a public hearing, but as Mr. Bottaro said, that's for the policymakers to decide, and hopefully there'll be an answer presented to the Springtown meeting. Thank you.
Thank you. You ready for the question, ladies and gentlemen? Do you wish to say anything, Mr. DeVaro? No? Then this lady up back there. Over the...
I just want to publicly thank the town meeting in general and the gentleman over there who complimented. This could have been a very ugly proceeding. I think that this is moving towards whatever the vote is going to be, it's going to be a useful decision that the town can move forward on. Thank you.
Thank you. Ma'am. Yes, ma'am. Wait for the mic. Yep.
Hi, Carol Savage, Precinct 5. I confess to not having attended the hearings on this, mea culpa. But I do feel that perhaps having voted on these changes in the prior town meeting, we were ill-informed about the significance of the changes to the bylaw as it might affect neighbors who surround these properties. And by adding A, B, and C in, we have allowed for exceptions to what is considered non-conforming properties when properties might be expanded significantly without giving notice to neighbors. So while I'm somewhat sympathetic to this, what seems like an arbitrary 25% limit, I am sensitive to how homes can be increased excessively, and that neighbors would not necessarily be notified if we were to approve this. So I don't know how to vote on this, and I don't know that I'm clarifying this for myself or anyone else, but I don't feel like what we did in the last town meeting to the zoning bylaw was fully fleshed out, and I'm not sure that this vote addresses it.
All right, we'll take two more. Mr. Friedel and the gentleman up back.
Thank you, Mr. Moderator. I think I heard in that analysis from special counsel that we were going to have the bylaw as it is proposed in this motion on Article 18 without the 25%. But then in the process of putting that bylaw in place, or that's the way it was, we had this Supreme Court decision which came down, which is why we have the 25%. So my question to the planning board is, if not for this decision, which I'm resisting saying because I'm not sure I'm going to pronounce it correctly, but if not for that decision, were we having a problem? I mean, I don't recall ever seeing a zoning bylaw coming forward here saying we had a problem with this particular issue. So if we haven't had any serious problems with this and the existing bylaw works, and special counsel has said to us that this is ABC, this article can work, and we're going to get something in the spring, I hope, that's more specific and detailed from the planning board. I would say we should move forward and adopt this and vote favorably on this article, unless we hear that this is really, for some reason, is.
Thank you very much, Mr. McGurl.
Denied their rights to build a home in this town. So you have to think about that as well. A few weeks back, the town staff met with Mr. Bobrowski, and we went through this whole issue about the 25%. And I know, as he mentioned earlier, the Borkland case, but it seemed pretty clear to all of us that the 25% rule, while not a made-up number, there was no hard and fast reason for it. We could just have had 50%, could have had 100%. But in the past, we didn't have any rule in that at all. And another issue is where they keep mentioning developers. There aren't that many developers here in this town building big homes. More often than not, it's someone's having another baby in the family, or converting a ranch to a colonial, or something along those ideas. So I think if you have a home where you'd like to stay in that neighborhood, and most of us always lived here a long time here in town, you want to stay, you should have that right to be able to do it, as long as you conform to the current zoning, which is all this is. Taking the 25% rule out just picks up the pace for everybody and not has to hold us back in the 6 months. Thank you.
Thank you. You ready for the question, ladies and gentlemen? There's a no up there. Yes, ma'am.
I'm Susan Humans from Precinct 5, and I don't like an I wonder question, and I'm afraid that's what this is. Nonetheless, if we pass this article, I understand from what both Mrs. Savage and Mr. Bottaro said that in some ways the hole that's made in this article is a bigger hole. It allows more things through than the previous status quo. So if people undertake under this bylaw, if people get permits under what we pass, if we pass this, what do we do at Springtown meeting when there are people in whose interest it is that we don't make any changes? So how can we make this buck stop? Thank you.
The question is, how can you make the clock stop? And I think the answer is you cannot. The clock right now there's no clock on the existing one unless this town meeting acts, changes it, and then if it's going to be changed again, I would think that the people who act between now and the time it's changed enjoy the law that's in place at the time. And that's the problem, and that was the problem when this got passed. Without the discussion we've had tonight should have been held when we passed the zoning bylaw recodification, and it wasn't. And so now we're doing that, and the time has come to vote which way we want to go. Are you ready for the question? Yes. Okay, the question comes on whether to approve the amendment made by Mr. Johnson and the Board of Selectmen to change the zoning bylaw in accordance with the motion in Article 18. All those in favor of endorsing that, please rise and the tellers will count. 14. I'm sorry, Mr. Johnson? 34. 21. 30. All those opposed, please rise. Two. 5. 10. 6. 4. Who said 4? Okay, we're going to do, I need that count on the, no. Leland has 4. Quill? 5. 6. 10. "99 having voted in the affirmative, 25 in the negative, a total of 124 votes required, total of 124 votes, 83 required for passage. The motion passes." Thank you very much. Okay, ladies and gentlemen, that brings us to Article 19. It's moved and seconded that the town vote to amend the Winchester zoning bylaws, and that's found on page 33, by amending or adding the following sections with regard to section 513, table of off-street parking requirements. And this is sponsored by Mr. John Sullivan, and all those in favor? No. Ladies and gentlemen, I have never sponsored an article as the moderator, and the reason that I did was when the confusion arose here, there were 2 articles that jumped out as potentially that needed some attention, and not realizing that seeing anybody moving to try to correct those, I drafted 2 motions, one on Article 8, which turns out to be like 18, and one on the parking. And the parking is strictly, and I think Drew Bataro will agree with me 100% on this, that the parking is just a mistake that happened in the codification, and it had 2 uses, the hospital and the other charitable organization, and then there were parking restrictions. And somehow in the recodification, those 2 uses got combined, and so they had only 1 parking criteria, which is 1 space per hospital bed, as I remember, which works for the hospital, but it doesn't work for anybody who hasn't got a hospital bed that's a charitable organization. And so all this does was separate them and revert exactly back to what we had. And that's the motion you have on page 33. And I believe that the planning board recommends favorable action. They also have asked that an amendment be added, and the purpose of their amendment, and I will read that amendment, we'll pass that amendment first, and then we'll pass, hopefully, the amended. When they reviewed this amendment and agreed with it, they realized that another table had the same numbering system, and because when we correct it, all we have to do is correct the numbering system in another table that refers to these same uses. So the motion to amend is to add a bullet, another bullet under the 3 that's in the motion, and it says the additional bullet, and this is a motion to amend, to renumber 3.1 Table of Use Regulations, Group 2, educational, institutional, recreational, and agricultural uses from number 10 to number 14 inclusive, to mimic the numbering for the parking table. We're changing the parking table. They want to just take the new numbering and mimic it over there. All those in favor of that motion, please say aye. Aye. Opposed? The ayes have it, the motion carries. Does, Mr. Pataro, do you want to say anything on that at all? He says no. Thank you. Anybody else have any questions or anything? Hearing not, I'll try a voice vote. All those in favor, this takes a 2/3 vote. All those in favor, please say aye. Aye. Opposed? The ayes have it, obviously unanimous, more than the 2/3, which brings us now to Article 20, definition gross floor area. It's moved and seconded by the planning board that the definition of gross floor area be in the Article 20 be indefinitely postponed. All those in favor, please say aye. Aye. Opposed? The ayes have it. Motion carries. Article 21, to see if the town will vote the zoning bylaw of the town of Winchester, Section 10, definitions height of building. And the planning board, again, it moves and seconded that Article 21 be indefinitely postponed. All those in favor, please say aye. Aye. Opposed? The ayes have it. The motion carries. Article 22, to see if the town of Winchester will vote to amend the zoning bylaw of the town of Winchester, and the motion is found on page 39, moved and seconded that the town amend the zoning bylaw of the town of Winchester, Massachusetts by changing the following numbers in section 885 dimensional requirements, and it reads as shown on page 39. And Mr. Batara.
Thank you, Mr. Moderator. Members of town meeting, I'll address all 22 through 26 are all in the category of what I would call Scrivener's errors. Had they been detected within the correction period, we would have made those corrections. They just simply did not translate over from the prior zoning law properly.
Okay, what articles were those that are Scrivener's errors? 22, 23, 24, 25?
And I think 26.
Is the swimming pool a Scrivener's error too?
Yeah, it was
25?
inadvertently dropped. It was. I'm sorry. That was the one where the height of the fence was
4 to 5 feet.
We had a town meeting that changed it to 5. The original was 4 in state law, and somehow that change got lost in the translation.
Okay, so that brings us, let's go to 22 on page 39. It's moved and seconded that the main motion shown on that page be approved. This is recommended by the planning board as a Scrivener's error, correcting a Scrivener's error. All those in favor, please say aye. Aye. Opposed? The ayes have it. Motion carries. Chair declares it was unanimous, obviously more than the 2/3. Article 23, a motion on Article 23. It's moved and seconded the town amend the zoning bylaw of the town of Winchester, adding the following language in Table 513 off-street parking requirements, Group 4. This is also a Scrivener's error being corrected. 2/3 vote required. All those in favor, please say aye. Aye. Opposed? The ayes have it. Motion carries. Chair declares that it's a unanimous vote, obviously greater than 2/3. 24, it's moved and seconded that the town amend the zoning bylaw of the town of Winchester, amending section 513, table of off-street parking requirements, another Scrivener's error. 2/3 vote required. All those in favor, please say aye. Aye. Opposed? The ayes have it. Motion carries. Obviously more than the 2/3 vote, unanimous vote. Article 25, moved and seconded the town amend the zoning bylaw of the town of Winchester by adding the following to section 412. The maximum build factor shall be 20 in the RBD 10 and RDC 15 districts and 25 in the RDA 20 district. This is a Scrivener's error correction. It's moved and seconded that the main motion be approved. All those in favor, please say aye. Aye. Opposed? The ayes have it. Motion carries. Obviously, the chair declares that that was a unanimous vote. And that brings us to the last zoning article, Article 26, to see if the town will vote to amend the zoning bylaw of the town of Winchester by adding language to section 442 swimming pools. It's moved and seconded that the town amend the zoning bylaw to the town of Winchester, adding the following language to section 442 swimming pools in the proper numerical order, and it reads as is listed on page 45. All those in favor, please say aye. Aye. Opposed? The ayes have it. The motion carries. Obviously more than the chair declares it a unanimous vote. ladies and gentlemen, that leaves us with 27, 28, and 29. And it's 10:20, and the Historical Commission came to me up and said, is there any chance that we will get to the Article 27? And I said yes, and he said he was leaving. No, I told him we'd never make it, and we would take it up on the 18th. So that's really the last motion other than the ones we postponed. So I think we're ready to adjourn. I just want to thank everybody tonight. This is zoning articles can be boring or exciting, but they're very important. And I thank you very much. And it's moved and seconded that this meeting be adjourned until 7:30 on the 18th. On the 18th now, not Thursday, not next Monday. All those in favor, please say aye. Aye. Opposed? The ayes have it. And ladies and gentlemen, I declare the meeting adjourned.
Okay. Good evening once again, ladies and gentlemen. As you can see, the town meeting just, okay, I'm back. All right. All right, town meeting has just adjourned this second session of Winchester's Fall Town Meeting. So let's do a recap of what has gone on this evening, a very busy session. We started out with the report from the Capital Planning Committee, which was Article 10. Doug Marmon talked about a very ambitious capital plan that will require a tax override, mostly for the reconstruction of the Vincent Owen School and a $1 million plus study of the Winchester High School, both of which they hope to get 1/3 reimbursement from the Commonwealth of Massachusetts, and a $1.5 million reconstruction of the Lynch School roof, also 1/3 reimbursed by the state. We heard about the poor condition of the DPW buildings, a request for a geographic information service, survey update, improvements to disability access, flood mitigation, scale house at the transfer station, roads and sidewalks, a trash hauler, trailer, and water and sewer projects. We heard from Chairman Marmon that the Building Stabilization Fund will be depleted in 2015, would probably remain depleted until 2020, which is dangerous for the town, but he also said it was a small price to pay if two major school projects are done. Now, moving on to, that was voted to just accept the report. Article 11 was two items, one $71,000 for a geographic information system, a flyover of the town in the spring to update the town engineer's database, and a $30,000 study for the DPW facility. Both of those failed. Town meeting did not approve either of those amounts. Article 12, which is the Vincent Owen School reconstruction, was postponed until our next session on the 18th, as was the $1.3 million request for a WHS study. And those were postponed to the 18th because the state will be voting on the amount, will be deciding on the amount to be reimbursed on the 17th, so the town did not feel it could go forward until after that was studied. Article 14 was a $1.4 million reconstruction of the Lynch School roof. We heard that building was built in 1961. Again, the state will reimburse about a third of that cost to put a roof on that'll have a life of 30 years. Town meeting approved that appropriation. Article 15, to adopt a stretch energy code for the town that would make a more stringent building code in the town in return for making the community eligible for state aid, was postponed until the 18th. Scribner's error in the wetlands bylaw was approved just to comply with state rules. After recess, Article 17, to remove Section 3.5.5 from the zoning bylaws, which dealt with some non-conforming properties, was indefinitely postponed. There was a request of Selectman Johnson because other sections of the bylaw depended on it. So that moved on to Article 18, which was a proposal by Selectman Jim Johnson to remove a 25% limit on increases in non-conforming properties. Jim Johnson in his presentation said that recodification of the zoning bylaw, which occurred in April of 2009, affected about 1,600 properties in town. He said that the planning board had said there were no substantive changes when the law was recodified, but apparently he felt that something that affects 1,600 properties was a substantial change. What happened was that Section 3.5.5 introduced a 25% limit on gross floor area increases as of right with non-conforming properties. In other words, if you had a non-conforming property prior to the enactment of this zoning bylaw, you could make improvements to it subject to the building commissioner's approval, and as long as you didn't increase the nonconformity. Introduced in this recodification was, unless you increased the floor limit, gross floor area by more than 25%, in which case you had to go to the Zoning Board of Appeals for approval. Jim Johnson, Selectman Johnson, said that condition should have been reviewed by town meeting, and the planning board could, of course, bring that forward next spring if they felt it was important enough. Drew Patara, the chairman of the planning board, said that he was very sorry if he did not, or the planning board did not meet the expectations of being transparent in the recodification. He said this change came to the planning board's attention only in September of 2010, and the planning board may need to analyze why so many non-conforming properties are affected. John Jubilo tried to, town meeting member John Jubilo tried to amend to involve the Zoning Board of Appeals in all building permits, and that was ruled out of order by the moderator because of insufficient notice to the town meeting members. Attorney Larry Murray said he was speaking on behalf of the Chamber of Commerce that recommended favorable action in repealing this section of the bylaw. He said he had 40 years of practice in the town, and the recodification of this section of the recodification was a substantial change, and asked why not require special permits on all projects. Town meeting member Anthony Conti said this was unfair because it only affected homeowners of existing properties, and in his opinion, the town should be encouraging improvements, not discouraging, to older non-conforming properties. Robert Abramson spoke, not a town meeting member, just a member of the audience, spoke to say that a personal story was he and his wife bought an old Victorian that was too close to the street, and now they are going to have to go through, or they would have to go through the ZBA process, and they would lose their construction loan because of the length of time, and will have to pay, even though he said the changes should have them be paying $3,000 to $5,000 more per year in taxes every year to the town. And he also said, as an attorney, in his opinion, the state law does not allow the town to add this 25% rule. The selectmen, at this point, we heard from Chairman of the Board of Selectmen, Tom Howley. Selectmen previous to this point had not taken a position on this. This was brought forward by Selectman Jim Johnson. But Tom Howley said that the selectmen had taken a poll right there on the floor and voted 4-0 to vote approval of this, recommend approval of this article. We heard from Attorney Brabowski, who was involved in the recodification of the law, who referred to this as the quote-unquote black hole of zoning. He also said that this change was presented at town meeting and approved. The cap was not necessary, the 25% cap was not necessary, but the town can cap, in his opinion. We heard from Dan McGurl, who's also the town assessor and a town meeting member, and he gave an example of someone who had a 10,000 square foot lot, does not need a special permit to make modifications, and yet somebody with a 9,999 square foot lot does need to go through the zoning board of approval permit process. He also said that in response to another town meeting member talking about many developers coming into town, he says there were not that many developers, and that most of these changes are being made by single-family homeowners. And that concluded the discussion of the article, and the article was passed by a vote of 99-25 to rescind that section of the law, more than the 2/3 necessary. An article, a lot of Scribner's errors, as they say, for some cleanup in the bylaws. One was put forward by the moderator, article number 19, to amend the table of off-street parking. Again, he just said it was a mistake in the codification and only worked if you were a hospital. So it needed to split up. So that article, Article 19, was passed. Articles 20 and 21 were indefinitely postponed by the planning board, or a request for indefinite postponement by the planning board, and those were approved. One dealing with gross floor area definition, another with building height in the zoning bylaws. And then Articles 22, 23, 24, 25, and 26, again, what they refer to as Scribner's errors, just minor errors in the recodification, were all passed by town meeting. And that brought us to the end of this second session of the fall town meeting. And as the moderator just said, the next session will be on Thursday, the 18th, this Thursday being a holiday, and again, some of the articles requiring waiting till after the 17th. So we'll be back with our live coverage of the third and presumably last session of fall town meeting on the 18th. We thank you for joining us tonight, and it's a relatively early night for a town meeting. So for all of us here at WinCam, I'm Alan Iden. Have a great night, and thanks for watching.